Hello, 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 everyone. Welcome to another membership surprise live stream. What I'm going to do on this live stream is chat and hang out with y'all, but also show you the process of what it looks like when you stream. So I'm going to give you some insight for those who are interested. And then if it's a good stream, I'll publish it to the public so we can all see it at a later time. So, what I'm going to do is share with you first. Whenever I talk about Richard, which of course, if you watch this enough, you know Richard. I'm going to share with you the work that Richard has put in, so you can get insight into what it is that we do. Hey, Triple Threat. So this is the spreadsheet um, that we use that Richard created for tracking everything. So if you look at the tabs down below, those little things down there, each tab represents um, millions, not millions, thousands. So this is, for example, 2022. This is Louisiana 2022. So Richard documented, for example, at the top here, January 3rd, 2022, name in DOC, the URL, the timestamp, highlight. When I highlight it, that means that I've done it. Richard then includes all the links, as you can see, and and then he also includes commentary, as you can see here. So I don't know how he does this, but look at how many hearings he's covered, and this is just the year 2022, and it goes on and on and on. We also have a color code system. So like pink, it means it's a female. Red means like, man, do check it out. It's an intense hearing. Purple means that what does purple mean again? Let's go to the color code. So we have, of course, our whole color code system. Here it is. You see this is the Richard notes, of course. So we have our links. So high interest, orange is a sex offense, DUI, parole violation, deceased, female, and related hearings. So, I mean, as you can see, what this is now just Connecticut hearings. We have the backup channel, which is, I mean, Mandu too, but these are for other hearings that, maybe Miss Rose makes a recommendation or Richard finds something that, or one of you make a recommendation, and then I'll send it to Richard and he'll do all the research and organize it just beautifully, right? So when I do decide to do it, I can, like this pairing right here, I have all the information. It just, I hope that this kind of paints a picture as to how easy, I call it Richard makes softball pitches for me. Um, and it's just incredible. So what we're going to do now is he is triple threat. We're going to pick a hearing and we'll do it together. We will record it together. We'll watch it together and then I'll do the unpacking together. So let's see what we want to pick. I'm going to go to top of 2022 because there were some hearings that I think I've missed here that are interesting. So sometimes the trick is to go to the red one. To the red. Well, here's one that's interesting. So, where did it go? 1989 molestation of 5-year-old, carnal knowledge, 13-year-old disabled girl, and a 2000 sexual assault. So this is insane. How did I miss this one, right? So then I'm going to go here and pull the DOC number because it is possible that I have recorded it, but I didn't document it. So I'm going to check my side here. No. All right. So let's go jump in. It's on 108. An hour and 8 minutes. And let's go. Hey, Griggs, if you click reverse, you can catch up, put it on 2x speed. You'll see what it is that I'm talking about here, but we're going to go jump into a stream. And this looks like a pretty insane one. So let's, so because Richard put in the timestamp right here, I'm able to track it, which is 108. So I'm going to go to 108. And let's jump in.
At the end, you'll be allowed to make a brief statement before the board votes. Do you understand the process, sir?
Yes, ma'am.
Just real quick, I do want to announce we do have one participant who is the victim who will not be speaking. Okay, this is the case for Felton Kuzan, DOC number 240644, date of birth January 6, 1965, classified as a second felony offender, offense, forcible rape, habitual offender, sentencing date August 28, 2000, sentenced to a total of 50 years. Parole date August 1st, 2021, good time, not eligible, full term, February 5th, 2047. Is this information correct, sir?
Yes, sir. Yes, ma'am.
Thank you. Ms. Jackson.
Good morning, Mr. Kuzan.
Good morning, ma'am.
How are you today?
Oh, I'm blessed.
Okay. Your case is, my name is Bonnie Jackson. Your case has been assigned to me, so I'll start questioning for the board.
Yes, ma'am.
You're 56 years old, Mr. Kuzan?
Yes, ma'am.
And how much time have you served on this charge?
I've been down since 1995.
Okay. You don't know how many years that is? It's about 27. Does that sound about right?
Right in between that, they're about 20 something.
Okay. Kuzan, you know, this is a really difficult situation that we have before us this morning.
Yes, ma'am. Yes, you
do. This is a rape of a mother in her home with her children present. You knew her somewhat because you were the cousin of the victim's friend, so you kind of knew of her or she knew of you. You were already you'd already been convicted of a molestation of a juvenile, and that child was 5 years old at the time. You also had an arrest that was not prosecuted, but it was for carnal knowledge of a juvenile of a 13-year-old mentally disabled young girl. Is all of that true?
Yes, ma'am.
Okay. I do see that you have completed all phases of sex offender treatment. So let me talk to you about that. What did you learn about yourself in those sex offender classes that you took?
What I learned about myself is about, watch my surroundings, watch the type of people that I build on.
No, that's not about yourself. I mean, your surroundings and the people had nothing to do with your molesting a 5-year-old girl, a 13-year-old girl, and raping the victim in this case. That has nothing to do with your surroundings. What I want to know is, what did you learn that helped you understand why you were committing all of these sexual offenses?
Yes, ma'am. What I learned, not to do drugs that would cause me to do, not to do drugs or drink that cause me to do them type of things like that there. and admit to myself that I know that is wrong, that you can't go around drinking and getting high and doing people them type of things.
Well, but Mr. Kuzan, a lot of people drink and do drugs. And they commit crimes, but they're not sexual crimes. They don't rape people. They don't molest babies. A 5-year-old is just a baby, and they don't have sex with a 13-year-old who has mental disabilities. None of that has to do with drinking. That has to do with something in you that you have these urges to have inappropriate sexual conduct.
That's why I took the class, so I could learn.
I know you took the class, but I want to know what you got out of the class.
I got out of class, I can't be doing things like this there, because that it caused me and put me in situations and places like this here.
Well, okay. Well, did you take victim awareness?
Yes, ma'am.
So what is victim awareness?
Victim aware that you have a victim.
That's
Yeah.
all you learned? Go ahead.
No, I learned victim aware that you have a victim. You got to learn the victim that you have, that you hurt their families, their loved ones, and stuff like that. Then you got to remember and apologize to the victims and their families and what you called them harm.
Well, let's talk about harm. Let's go back to that 5-year-old girl. What do you think it did to her to have a grown man molest her? What do you, just thinking about it, what do you think your actions did to that little girl as she was growing up?
Well, my action, what I think I done to her, that I have ruined her life, and that, I know that I was wrong for what I did, but I really didn't molested her, no. See, this is my father was staying with her mother, and they had left the kids by the house, and I thought I was doing the right thing by bringing them to my mother's house. And I had kids.
But again, Mr. Kuzan, you were either convicted or you pled guilty to molestation. So we're not here to retry the case. All right?
Yes, ma'am.
Let's talk about the rape. How do you think your actions affected that woman that you raped in her home with her 3 little children present? How do you think your actions might have affected her life?
Very harm. I think I affected her very harm, and affected her life very, in a very disrespectful manner way.
Go ahead.
And I know that, I asked the victim and their family that they would please have mercy upon me, and, that she knows that I had a mental problem, and I wish I wouldn't have done them type of things to her.
Well, tell me, what kind of mental problem did you have?
I have a nerve problem, and at that time I was hearing voices and everything, because I was taking treatment in Jackson, Feliciana before I come here for a year and a half.
Are you receiving any kind of medication right now for mental health?
No, ma'am, I was taking Thorazine, but it was messing me up.
And when did you stop taking Thorazine?
About a couple of years ago.
When you say messing you up, what do you mean?
When I was taking it, it was messing with my mind. I was hearing more voices, and it was dropping my sugar.
Okay. Well, it's concerning that if you have a mental health issue and you're saying these mental health issues contributed to your committing these crimes, and now you're telling me you didn't want to take the medicine because it was messing with you, then it makes me worry about you being out and you're not being willing to take medication.
When I was out, I take my medicine that slightly of mental health. That's why I was taking.
But it didn't stop you from committing these crimes.
But I choose another selection that I start serving God and give my life to God, and say, like I told Mr. Pastor Holloway, that I was going to join his church when I get out. and get in the choir.
Okay. Warren, what could you tell us about Mr. Kuzan?
I know he's going to the church services and he has been through all the sex offender treatment program classes we have. I will address, I did look in, we do an interview with him prior to the board. I did look at the last two write-ups he had. They were having a problem. He was getting some pressure on him by some inmates in the dorm and he handled it badly. They kind of explained that he made comments that were, threatening, but it never, it was because they were pressuring him. And once we moved him, we didn't have that problem anymore.
And that was in 2020?
Yes, ma'am. Outside of that, his record speaks for itself.
Right. Thank you very much. Thank you, Mr. Kuzan. I appreciate talking with you. And Mr. Wise,
Yes,
that's all I have.
Thank you, ma'am.
Okay.
Yes, sir. I don't see anyone else be speaking. Anything you'd like to say to the board before we vote?
I'd like to say, I will ask the board to have mercy upon me and let me go home and take care of my mother and join Mr. Josh Holloway church and join his choir. Because I told him whenever I get out, I'm going to come and join his church and get in this choir. And I asked that the parole board, would grant me this board, and I showed the board, not only them, myself, that I become a better person and become a better citizen out there.
Right. Okay, well, thank you very much. Ms. Bonnie Jackson will be asking some questions.
Thank you, sir.
Mr. Kuzan, you have done some positive things since you've been incarcerated. I'm glad that you've taken sex offender treatment and victim awareness, but I'm not quite sure that you've gotten out of those programs what you need to get out of them. You have a history of sexual crimes, a molestation of a 5-year-old girl, sex with a 13-year-old mentally impaired girl, and then rape of a woman with her children present in the home. Those are all very troubling things. You've indicated that you have mental health issues and you have declined to take the medication. You have a high risk assessment. You've got strong opposition from the judge, the DA, and the sheriff, and the victim of the rape is strongly opposed to your being released. And so for those reasons, Mr. Kuzan, my vote today is going to be to deny, but I encourage you to keep working.
Yes,
Maybe you
ma'am.
need to get back in the sex offender classes. I know you just completed them in September, but I just don't feel like you've gotten a real understanding of your conduct and why you commit sex acts against victims. But my vote today is to deny.
All right, ma'am. Thank you.
You're welcome.
Mr. Roche.
Thank you, Mr. Chairman. Mr. Kuzan, good morning.
Good morning, sir.
Good. Mr. Kuzan, I really don't think you have any idea, not one bit of understanding on the damage that you did to your victims.
Yes, sir.
The victim is still mentally, physically, and emotionally affected by this crime. Her 3 daughters are affected by this crime. They were in the next room, and you threatened the victim that you would do bodily harm to her daughters if she didn't cooperate. What mother would take a chance of getting her children hurt? And you knew that. You were not intoxicated. You were not on drugs. You knew exactly what you were doing. The victim is vehemently opposed to any clemency. The DA office is opposed. Law enforcement is opposed. You have a high risk assessment. You have a high needs assessment. And quite frankly, Mr. Kuzan,
Yes, sir.
I still think that you're a danger to public safety. For all the reasons I just articulated, my vote is to deny your request.
Yes, sir.
At this time, I'm gonna be voting, Mr. Felton, I think you need to work on some more programs. You've been down a long
Yes,
time. You got some serious crime, high risk, high needs assessment. Work real hard while you're in. Today, I'm gonna vote the same as my colleagues. Thank you very much.
Well, thank you, sir.
Good night.
All right.
All righty. Yeah, we'll take care. All righty.
Yeah, there you have it. You can't make it up. Really, this is like the definition of if you didn't see it, you might not believe it, because how is it possible? How is it possible? You hear the list of Miss Jackson going over, and even she seems dumbfounded. But what makes it even worse, if that's possible, even worse. But what is that? Remember that he got away with these offenses. It's the system that allowed him to get away with it. They didn't even prosecute him on, maybe it was the 5-year-old or the disabled 13-year-old, which is what allowed him to then have the third offense. So it's, again, until we can start holding the system that's put in place, the legislator, the prosecutor, the judges, to protect us, it's should we yell at the monster? Should we yell at someone who is evil? Yeah. But really, what we should do is hold accountable the people in place that even allow it to happen. I mean, I'm looking at the information that Richard provided, and I can go back to the screen, because, for those of you who maybe just jumped on, the part of this stream was to show everything that what Richard does. So here's the spreadsheet, and I can't believe I missed this hearing. Really, I had to go back because it wasn't highlighted in red. So this is before we started the color coding thing. So I'll highlight it in red, and although he put the notes, But so here's all the links that Richard provided. 1, 2, 3, 4, 5. Now, I don't share these links because they have personal information and I'll get a YouTube strike. But it allows me to click on it and easily find what it is that I'm looking for. And he has the date of conviction for molestation of a juvenile on April 10th, 1989. It says that he was revoked. It doesn't say when, but he was released in 1997. So, and it says he was released on his full term date in 1997. So what that means is that we're not 100% sure. Either it was the 5-year-old or it was the mentally disabled 13-year-old. But it means that he only served, in 1989, he only served a few years because he was paroled. Then he was revoked, and I bet you it was for one of these other offenses he was revoked for, and they didn't try him. And then he got out in 1997. So at most, he got 8 years for molesting a 5-year-old. But we know he got less than 8 years because he was paroled, re-offended, and then got in his full-term date. So again, that's the system. That's the system. Then it was in year 2000 that he sexually assaulted a mother in front of her 3 kids, and he got the 50-year sentence he has today. His full term date is 2047. And I'm going to probably I want to do this hearing as a stream. Do you guys mind if we redo it as a premiere? Because I can't, this is just, this one is one of those in the books, hearings that are just absolutely insane. And Laura, thank you for the super chat. Appreciate it. Yeah, even when you know it's bad when even Griggs thinks they should be locked up indefinitely. Yeah, I'll do it again. I just really, from seeing this, I didn't say I didn't know what to expect. I couldn't believe it. It's like, not that I couldn't believe, but what's good about this hearing is that it's a Miss Jackson interview. So it's not like Jim Wise or Miss Wise or Brennan Kelsey just like, oh, okay, yeah, great. And to top it off, you have a Mr. O'Shea mic drop. So it's like those are the hearings that I like to find. Yes, I am live, Mr. Jesse. Yeah, buddy. I am live. It's a surprise live stream. Hello, Phyllis. Well, you know what's interesting is that I'll spend a lot of time in the day doing the stream. So what if I do a live stream to the members only? Because I'm sitting here anyways, and then I just record it. But the problem is that there'd be too much editing. Jesse. Yeah, buddy. Yeah, Griggs. And just think about this. There is no one with any rational thinking that would say that he's only offended 3 times. No, it means he was caught 3 times, which means there's no doubt in my mind that he was probably offending against that 5-year-old since that 5-year-old was born, or that he was offending against that mentally disabled 13-year-old for years, and that he has probably hundreds of victims. Hundreds. Yeah, buddy. And just to think about that, and then again to think that it's the system that released him on parole. He got revoked. They didn't resentence him, and he did it again. Yeah, exactly, Griggs. I mean, he is hundreds of victims, maybe more. Yeah, we can do. Yeah, I'll definitely show this one again, but I'm gonna probably going to. I'll edit it down and just do a new unpacking. Because non-members, they don't really care to hear me talk. they want to see the hearing. They don't want to hear all the ramble. The CT hearings, no, but we could talk about the CT hearings. Phyllis, the Connecticut hearings bother me so much. It's funny. I'll go and I'll do like a half a day of recordings for Connecticut hearings. So it's like I'll go in there and yeah, we could watch a Connecticut. You love them? I can't stand them. I don't know. Okay, I shouldn't say I can't stand them. Sometimes they're a crack up. Like I laugh. They're actually funny in some ways. But what I don't like is how pathetic the board is. It's like to me, it seems like the parole board are like coddling them. It's like they're in an elementary school, and it's where everyone wins a first place trophy. And then it's funny because it's gotten me to appreciate the Louisiana parole hearings so much more. I mean, the culture in Louisiana versus Connecticut, the inmates seem more respectable. Just the way that they say ma'am and sir just seems more respectable. That they don't come into parole hearing cursing. There's just, even as 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 it's just like, it's like night and day in comparison. Yeah, you get a trophy, you get a trophy. You're like, oh, that's great. I mean, I watched a hearing the other day. The guy's a chronic drug dealer, and he tells the board, I have no victims. And I'm waiting for the board to say, what do you mean you have no victims? You're a drug dealer. And and they're just like, okay, yeah, I understand. I understand. Okay, let's watch a Connecticut parole hearing. We can do that. Let's see. So I'll show you the system again. So add to the stage. So this is how we find the Connecticut parole hearings. So I go to the Connecticut tab, which is right here, and we scroll up. So here's all our Connecticut. As you can see, there's quite an inventory. So these are the names. So the dates. So we have from 112. Only highlighted green means that I've done it. So there's quite a lot that, as you can see, I haven't done. I try to pick the most interesting for you guys. But also there's only so much time in a day. So let's see. See, these are female hearings. We can try. So then I can see what it is, because Richard does all this awesome stuff for me. And again, this is why none of his, whenever I say thank you, it's because like this is literally how hard he's working. So I get to scroll over the name and I can see interfering with an officer. He has his notes. He has the timestamp. And then I have it, for example, here, I see the sentence, arrest date 9/19/2022, maximum sentence 30 months, release date 2025. I have the links. Even listen, you see page 5, third paragraph. That's where I would get the news. Like, I mean, how thorough is this? I don't know. Is there anyone in particular that you want to see? Blue means blue is the color stamp. Let's go back to the color stamps. Blue is parole violation. Green is DUI. Red is deceased. Pink is female. Orange is related. So parole violation. PO, disrespectful, using deviant behavior term. This is a revocation. You want to do this one? Let's see. Are there any specific hearings that you want to do? This one is drunken disturbance. Oh, he has that evil attorney. Let's do this one. This one looks interesting. So I have the timestamps. I know when it's going to start. I'm going to share this tab. I'm going to click up. And it's a parole revocation hearing. I know Griggs likes that. Okay, let's go.
Determine if there's probable cause to believe you committed an act that violated the conditions of your parole, to determine if the act is sufficiently serious to warrant the revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you, and this hearing is being recorded. So to go over your rights today, Mr. Pierce, you have the right to be represented by an attorney at this hearing. You may hire your own attorney. If you cannot afford an attorney, you may qualify for an appointed attorney to represent you, which you have exercised here today. Sorry. You have the right to receive written notice of charges of violation. Did you receive written notice?
Yes.
You also have the right to review the evidence against you before this hearing, and you have the right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine any adverse witnesses. Do you understand these rights?
Yes.
And Attorney Famighetti, have you had sufficient time to prepare for today's hearing, and are you ready to go forward?
Yes, and I believe I may be the sole party speaking today regarding probable cause, standard, and seriousness.
Okay, if that were to change, please let me know so that we can get Mr. Pierce sworn in.
Thank you.
All right, so what we're going to do is we're going to review the charges that Pearl Community Service is bringing against Mr. Pierce and the information underlying each charge. I will be reading the charges in lieu of the parole officer not being here to read them. So on charge number 1, under obey all laws specific to obedience to the law, the charging officer writes, on February 3rd, 2024, contact with the Putnam Police Department was made. Upon contact, officers observed you outside of your vehicle, unsteady on your feet, speaking with slow and slurred speech and exhibiting very exaggerated movements. The officers attempted to investigate the reasons you were there and if you were under the influence of any substances. During these interactions, you became confrontational and continued to refuse their assistance by swearing and spitting out the officers and medical staff when they were assisting. Due to your behavior and refusal to cooperate, you were placed into custody and transported to the Putnam Police Department, where you were charged with breach of peace in the 2nd degree. Due to your arrest, you are in violation of the standard condition obey all laws, Section A, obedience to the law, criminal. The evidence that Pearl Community Service provided include Exhibit A is your signed statement of understanding and agreement conditions of parole. B is the remand to custody order. C is the violation notice of parole violation. And D is the parole violation report. E is the Putnam Police report ending in 1555. F is the Putnam Police watch guard body camera footage. That is all of the information that I have at this time from Pearl and Community Service in regards to evidence. And as I stated earlier, I do not have a parole officer to provide me with any further information. So Attorney Famighetti, now is your opportunity to respond to these charges.
Yes, although the defendant may have been charged 1 obedience to the laws for him violating breach of peace 2nd degree. He did not, on February 15th, the charges were disposed of, and he did not plead to breach of peace in the 2nd degree. He received an unconditional discharge for disorderly conduct. I have proof of that here. So the allegation is that he committed the crime of breach of peace, which is not correct. Did not rise to that level. And he pled guilty to disorderly conduct, which is received an unconditional discharge. So for that reason, I don't believe it meets the preponderance of the evidence. And then as to the seriousness of the allegations, I reviewed the videotape. It's a lengthy videotape. I reviewed all of it. I reviewed it twice. It's clear, it's unequivocally clear that the officers were working with my client. They were trying to get him a ride home. They called, his wife called. They basically said, quote, we're looking to get Tyron a ride out of here. We are not looking to arrest him if someone could come and pick him up. Unfortunately, someone couldn't come pick him up. He was frustrated. There's no, he may have been using foul language. It's not a crime to use foul language. He may have been using foul language. He was upset. He had his dog with him. His dog had to go to the bathroom. I believe the police handled this very well. I believe this is an unfortunate set of circumstances. Unfortunately, fortunately, he pled to the disorderly conduct. Even though I don't believe it meets the standard, I certainly don't think that even if probable cause is found, that this is, quote, sufficiently serious to warrant the revocation of his parole. A number of times he put his hands up against the car and said, "Take me." He went voluntarily. He went without any force. He went voluntarily. He did not resist arrest. He did everything possible to minimize any violence. He was upset. He had no reason. He has a constitutional right to question why they were pulling him over. He was concerned because there was more than one police car there. He's like, "What is this all about? I'm just parking here to let my dog go to the bathroom." I don't think, taking the totality of the circumstances of this incident, whether there was a plea or not to anything, I don't think that this incident alone, he sat in jail since February 4th. I don't think this incident alone is sufficiently serious enough to warrant the revocation of his parole, and I certainly don't believe he should be detained any further. Thank you very much for your attention.
Thank you.
You're welcome. He's been on parole for 5 or 6 years. I don't know
Yeah.
any prior violations. So this is certainly out of
I
character.
agree.
Can I say something?
If you do, I do need to place you under oath, Mr. Pierce.
Please
Would you
do.
like to make a comment?
Yes,
All right, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
yes.
Okay, go ahead. Oh,
On
well,
the,
is this is with
on the video,
your conference?
Sir, I think we're in a good place here.
okay, I'll fall back.
Is there anything else that I have said that I didn't say as to, were you going to say what they said at the plea in court?
Yeah,
Okay, I'm comfortable with that.
the prosecutor said that my dog was running around the parking lot nuisance. The officers clearly let my dog out.
Okay, I don't think that is critical to the disposition here. I did see the video, and I don't think the dog was an issue whatsoever. In fact, given the set of circumstances, I think your dog was very well behaved. Okay, I don't think the officers had to worry about your dog whatsoever. Okay.
They were just trying to keep it safe.
Yeah, they were just trying to keep him safe, or her safe. Okay, thank you. Thank you, sir.
Thank you.
Now, I'm gonna take a brief recess on this. Yeah,
One moment, sir.
I'll be right back.
Okay, so I'm gonna unpack this at I suppose at the end, but Richard did provide all of the court documents, and the crimes that he committed are vile. And Griggs, he's not bright. He actually, one of the crimes that he did was that he offended against a woman who then pressed charges on him. So he took her to a hotel room, sexually assaulted her for hours, and told her that he would do it again if she didn't pull the charges. So he let her go, and she went to the police and told them what he did to her. So he got a really long sentence, but Connecticut, they're lenient on crime, so he keeps getting paroled and stuff. It's quite a ridiculous. Connecticut's messed up. Not if you want to do crime, then it's pretty great. But yeah, there's Richard, I don't know if you saw what I was doing earlier as I was showing everyone all the work that you do. And then I just clicked on a Louisiana hearing and realized that it was just an insane hearing. So I'll do another premiere. I'll do a premiere on that. And then pick this hearing from the spreadsheet. And this is also pretty crazy. I wonder what is she even You know, it's this attorney too. This attorney is just nuts. It's the here, I'll show you. I'll share the tab again. So as you can see here, this is how it's highlighted in the spreadsheet. And Richard puts the note, so I know that it's this preliminary attorney, Family Galetti, right? And it's also highlighted red. And then he has the timestamp. He has then all the notes and the links, right? The case links. So I'm able to just click through these different links and pull up all the info. And that's, so I've been reading it while we were watching the hearing, and it's disturbing stuff. It's like, I mean, this guy is just, so I could read some of it to you now while we're waiting. So this is what happened initially. So as docket ending 585, the defendant and victim who were in a relationship were at a party on July 4, 2004, when a dispute arose between them. They left the party and went for a ride. During that ride, the petitioner struck the victim repeatedly in the head, because why not, to the point where he knocked her unconscious. The victim reported the incident to the police a few days later. The petitioner was subsequently arrested. Our prince right here was arrested. And then you fast forward to 6 days later, July 10, 2004, the petitioner drove two female co-defendants, I don't know why they were co-defendants, in search of the victim. So it's him and two women, and they're looking for her. And she was hiding from the defendant because, she was scared of him, terrified of him. They found her in the inside of her apartment an apartment where she was staying. They forcibly dragged her by her hair and shoulders into the car, drove away while his co-defendants Angela and Becky held the victim, in the back seat. And they were slapping and punching her and threatening her during the drive to Connecticut. At some point, the vehicle stopped at an unknown road and met another vehicle being driven by an unknown male. The victim was removed from the car, where the petitioner proceeded to punch and kick her to the ground until the female co-defendants convinced him to stop. The petitioner then got into the second vehicle and drove away. The petitioner left the vehicle with an unknown male, while Angela and Becky forced the victim back into the vehicle and drove her back to the Budget Inn, where they rented a room. Rebecca then called the petitioner and advised him where they were staying. The petitioner arrived sometime later and began physically to assault the victim until a female co-defendant again convinced him to stop. Sometime thereafter, all of the other parties left, leaving the victim and petitioner alone in the hotel room. The following day, July 11th.
Okay, sorry about that delay.
Can you hear us, sir?
Yes.
Adjust your camera. Oh, no, that's fine. Oh, you mean to go further away? I like that even better. Thank you. The look is so much better from farther away. Start again. Oh. Pushing all the wrong buttons here. Okay, back on the record for Tyrone Pierce, 176-388, preliminary, back from recess. Thank you for your patience. I just wanted to kind of check something that I don't have over here, and just to confirm something. Was there anything further,
No.
Attorney Pamela? Okay. Okay, so on charge number 1, Mr. Pierce, I am going to make a finding on that charge that is based on the evidence that was provided, including your guilty plea, as well as the evidence, which include the video that I was able to observe, the police report and the parole violation report. I do find that the act is serious enough to warrant a revocation. I've also determined that you should be held in prison pending further proceedings. So what I'm gonna do is I'm gonna get you scheduled for a revocation hearing, and at that revocation hearing, myself or another hearing examiner will determine if you violated the conditions of your parole. And if so, the hearing examiner will make recommendations regarding whether your parole should be revoked and what, if any, sanctions should be imposed. So if you just give me one moment to look here, I want to, because of the holidays, our schedules are very different from normal. So let's go, pretty sure March 20th. The right day. I don't think it's the 19th. I think it is March 20th, but I can find that out in just a moment by looking at my previous ones that are scheduled here, and March 20th, yes. So I'm going to schedule you for March 20th for that revocation hearing. Right, and that's going to conclude the preliminary hearing for Tyrone Pierce, inmate number 176388.
Okay, sir, give me a call if you have a question. Your next hearing is on the 20th of March, okay? And we'll take it from there.
As always, that is tentative.
Tentative, right. Okay, sir?
Thank you.
Thank you for your attention, sir.
Thank you. I have to say that if there's a snowstorm, who knows what happens. Okay, thank you. Get my gear back.
Tentatively, she says.
At least I can move it.
I mean, what an attitude the guy has. He's sitting there like all gloomily, poor me, oh no. You know, he's got this public defender standing up for him. He's got his, it's just the whole thing is such a, but so 20th of March, he's going to have an actual hearing. So this hearing, and Richard, correct me if I'm wrong, is just a preliminary hearing to see if he should have a hearing. And the answer is yes, he should have a hearing. So they're going to have an official hearing, and his attorney's going to yell and scream and say how this poor guy. And see you, Griggs. Thanks for jumping in. Oh, we have Ducky in the chat. Ducky, I love Ducky as the new addition of the Mandy family. Ducky fits right in. Ducky, I was reading your bio on your YouTube. I saw that you feed like 20 neighborhood was it cats? You're like the neighborhood cat person, and also a widowed veteran. So thank you for your service, Ducky. And I love your sense of humor and having you in the family. It's funny how you come up with all these different versions of being a duck, expressing yourself. Cats, but amount to 6 pet hens. Yes. Right. So yeah. So where was I? Right. So we're going over. We're going over his court doc. Was it this one? Right. So he's upset that she filed charges against him, right? So so his brilliant idea was to kidnap her, beat her, take her to the hotel room, and sexually assault her. They left, leaving him, this prince, and her in a room. Imagine how terrified she is, right? She goes to the police after he knocks her unconscious. Then he tracks her down, kidnaps her, beats her with other people, takes her to a hotel room, and then sexually assaults her, forces her to engage in oral, digitally penetrates her, sexually assaults her twice with intercourse, and then when done, he allows her to leave, which she must have thought he was going to kill her. I couldn't imagine what else she'd be thinking. And he said that if she didn't if she didn't drop the charges, then he would do it again to her. Now, thankfully, the victim did in fact go to the police. Survivor went back to the police following the threat, and she did retract her story. Oh no, she didn't. She went back to the police following the threat. And what's this mean? Why am I having a hard time reading this? Again, the petitioner was arrested the strength of an arrest warrant. I don't know, I'm assuming she didn't retract her story, but I'm reading it strangely. Am I reading it strangely? Richard says these Connecticut revokes are so idiotic. You have a prelim where they go through each charge for probable cause, then a hearing to prove guilt, then the real board, right, has to review and approve the examiner's recommendation. And Richard, I was thinking about this. I wonder, I would love to find out what percentage the board agrees and does not agree with the recommendation. Now, my guess is that it has to be in a very high percentage, but at the same time, they have to, by default, not agree with everything, because it would look like basically like a Stalin court, right? If they agreed with everything, they have to have their own opinions. So I wonder what percentage they say they disagree with the recommendation, or maybe they add certain things to the recommendation, but there's no way it's 100%. But it is a dumb system. Makes no sense. The amount of time and money, 3 hearings to make a decision. And they assign them like a designated attorney, which is, you might argue that's a good thing. Someone might say, hey, if we give everyone a revocation, an attorney, then maybe we'll have fewer revocations. And Richard pointed out too, Connecticut has, like, I forget the number, one of the highest revocation percentages of all states. I forget the number, recidivism rates. So, again, it's follow the money. It could be they're like, well, how can we reduce recidivism? Let's give everyone an attorney, and let's give everyone a decent attorney, because as much as I hate the guy, I mean, he seems to be pretty passionate about his job, and he seems to do the homework and have and is aware, and he fights for his clients as if he's a high paid attorney. So I'm guessing they didn't just get any attorneys. They're paying, I don't know if that has to do with how much he makes or not, but right, 79% of parolees commit new crimes within 5 years. And I wonder how much, it's like a Freakonomics thing. I wonder how much has to do with their low parole rates, but also with their automatic special parole. See, the automatic special parole, which it seems that everyone in Connecticut has, the judge bakes in automatic special parole, increases, it skews the data, because in Louisiana, you get out not on parole, then, well, it's different. It's a recidivism rate. It's not a revocation rate. Okay, so never mind. Because you would still commit a new crime regardless of how you're getting out. Yeah, I know, it's like special parole. But the thing about the special parole is that it sounds like, on the face of it, it sounds like a goofy, pro felon thing, but it's actually not. Correct me if I'm wrong. Special parole is pretty intense. It's like a forced mandated probation. It's basically, what it means is, here's your 5-year sentence, but you're getting out after 5 years, but now you have 10-year special parole. You're on parole for 10 years. And you see that a lot. So again, we'll go back to what Richard showed here. And this guy has like forever special parole, which basically means he's just always going to be getting locked up. But his special parole date ends in 2033. You see what Richard does for me? So this guy has another 9 years of dealing with parole. That's not fun for anyone. So I don't think it's a pro inmate thing. He also has this guy. This guy's such a clown. He he has frivolous lawsuits against the police department. So here's a frivolous plaintiff alleges that 3 people, including the plaintiff's ex-girlfriend, forced their way into his elderly grandmother's apartment. So he's now suing the woman who he sexually assaulted and restrained her against her will and stole $5,000 from a suitcase that was hidden in a bedroom closet. The police apprehended the ex-girlfriend who confessed to the crime. According to the plaintiff, however, the police then failed to execute the subsequent arrest warrant, the ex-girlfriend. So basically, he civilly sues the police department over $5,000 that he claims his ex-girlfriend stole. And of course, they dismissed this action because they found it to be futile. And then he has another thing where he sued someone else. He likes suing people. This is in February 2016. It's interesting, the Freedom of Information Act. What does this mean? Is this did he FOIA this or did someone else? But he sued the chief of police department of the town of Putnam. Like, this guy is just a clown. I wonder where he's like, who he's getting to do these lawsuits. Is it a jailhouse lawyer or is he is his revocation lawyer, right? But let me try to find out. So the dates of his crime, he did this horrible crime in 20, which was kidnapping. I mean, here is the charges: kidnapping first degree, sexual assault first degree, assault second degree, tampering with a witness. Because the allegation involves sexual assault, only the victim initial. Okay, so these are a lot of serious charges, right? How much time did he get? How much time did he get? Does it say here? Okay, the state was proceeding trial charges, conspiracy to commit, both felonies carrying a maximum sentence of 25 years each, blah, blah, blah. Well, he's appealing his sentence, but where does it say the time? I'm just curious. I mean, it's not that much time. You'd think for this type of crimes, he'd be locked away a long time, but obviously not. Where is this? It usually says it on the top. Because look, the appeal only ended in 2020. Where does it say it? Oh, here it is. On December 12, 2008, petitioner was sentenced to an agreed upon total effective sentence of 10 years, followed by 15 years special parole. So he got 10 years. That is it. For all of these crimes. 10. You can't make it up. How do you get 10 years for that? How do you get 10 years for kidnapping a witness who is charges against you, beating them and sexually assaulting them? How do you only get 10 years? And this is it. Like, the system it's messed up. How can you define that as protecting people? And like they're supposed to, take that seriously. Like it's always like, oh, witness tampering. That's a line that you don't cross. But no, it's just not true. His attorney is Richard mentioned it before. Mandu, go to 785 and open call H comments. Okay, 785. So here, I'll share with you what Richard just said. So I'm going to row 785. You can see right here. I hope it's not a private comment. Let me stop sharing just in case. 785. Where's that? What was that again? An open column H comment. Right. Okay. Column H comments. Okay, it's fine. Yeah, I'll share this. Obviously, I can share this. Let me go back. Share, Richard. So look at what Richard's talking about. Column H. So this person, I don't know if you guys can see this. Yeah, you can see it. The best lunacy. So guilty of 53A, larceny 5th degree sentence 6 months in jail. Guilty of 53A, burglary 3rd degree sentence 18 months in jail. Criminal mischief sentence 1 year in jail. That was 2014. Then in 2016, so he obviously didn't serve all that time because in 2016 he does more stuff and gets a 30-month jail sentence. But apparently, here he has a 7/29/2016 4-year jail sentence. 7/29/2016 4-year jail, 6-year special parole. 7/29/2016. So I'm not sure. Are these redundancies or? You're actually gonna have to explain this one to me because looks like they're the same dates. Now this is different. 8/26/2016. 4 years. 4/19/2018. It makes you wonder where's all the prison time going if he keeps getting new charges. 6/16/2021, 30 months jail. And then it keeps going. Here's more charges. This guy's got a long record. I have a teacher parents virtual conference that I need to. It's like a phone call that I need to do. Oh, I actually need to go now, guys. I'm so sorry. It starts in 2 minutes. I did not mean to hang up like this, but I have it in 2 minutes. So I'm going to go. It's only going to last a few. Yeah, I have to go actually. So yeah, thank you guys so much. That was a lot of fun. I'm going to I'll redo these hearings. I'll redo the revocation hearing on March 20th once we get the follow-up. So and I'll mold it together and then I'll redo the that Louisiana hearing and do that as a premiere. Thanks, Triple Threat. Thank you everyone for jumping in. Thank you, Laura, for the super chat. Hugs. Quack quack. See you, Chocolate. Who did I miss? Hey, Carol. Phyllis, what's up? Lady Firebrand. And by the way, if I didn't say hi to you, I'm not ignoring you. It's that I don't have the chat open while I'm doing the stream. So it's I could miss things. Just want to let you know. If I didn't say hi, I am not ignoring you, I promise. Susie, what's up? Phyllis. And Sarah Mia. I like that name, Sarah Mia. Pam. All right, I'll see you guys.